Good morning, friends. This is Suresh, your commerce teacher from Government Degree College, Kukatpalli. Today, we will try to understand the essentials of Patents Act 1970. You all know that patent is one of the important intellectual properties we have in this country. So, what is an intellectual property first? How many types of intellectual properties are there and how they are protected? We'll have a glance once, then we will come back to Patents Act 1970. So, intellectual property is the outcome of human thinking. The name itself reveals that it is the intellect that creates property or asset. It is intangible in nature. Naturally, something which is the brainchild of an individual is intangible, is not seen with naked eye unless it is materialized into a product. It has got an economic value. Certainly, yes. So, intellectual properties are not having normal economic value. Rather, they will help you to mint money like anything once you obtain patent or copyright or trademark for your product. It deserves legal protection, especially when we make patents of innovations. The amount that we derive will create huge economic value, so it deserves legal protection. As I told you that we are going to connect shortly to Patents Act. So similarly, broadly classified, these intellectual properties are broadly classified into patents, copyrights, and trademarks. So for each variant, we have separate law to grant legal protection to your intellectual properties. Patents Act 1970, Copyrights Act, and Trademarks Act we have. So today we are going to learn about Patents Act 1970. After all, why your patents or any intellectual properties must have legal protection? Because they are your assets. Someone should not copy it, someone should not infringe your assets, your intellectual property without your consent. So, in order to prevent someone from stealing your property without your consent, so we need to have legal protection or legal remedies whenever such stealing takes place. Therefore, we need to understand that legal milieu protecting IP yards is of paramount importance in encouraging scientists, authors, and traders to work towards intellectual property rights. Right? So, today we'll have a discussion on the first one, that is patents. So, what is a patent? How it can be obtained? So, what are the inventions which are eligible for patent protection? So, how patent law works in this country, how it used to work earlier, and now how it is working, especially in the post WTO scenario. So, in WTO, we have an agreement called TRIPS, Trade Related Intellectual Properties. So, according to TRIPS draft, we had to make some amendments to the earlier laws, which we did, of course. So, let us see the entire concept of Patents Act. So, friends, imagine these three personalities: Sabir Bhatia, who created Hotmail messenger system; Varaprasad Reddy, the great Padma Bhushan Varaprasad Reddy, who has created vaccine for hepatitis in this country, Shanvac. Similarly, Bill Gates, we all need no introduction of this gentleman. So these three personalities, for example, could not have created such a big empire had their inventions were not been protected through patents, copyrights, and trademarks, isn't it? So they have virtually started with no amount in hand, but they have created a huge business empire, and they have put their indelible signature on the entire business world of this globe. So patents, copyrights, and trademarks will turn anyone into a greatest personality, provided such anyone has got intellect to innovate, intellect to write something and obtain copyright, or intellect enough to create brand equity for himself and create a trademark for such brand equity, right? So now let us go straight away to Patents Act 1970. In this discussion, in this chapter, we'll have only Patents Act for discussion. The next chapters will cover about copyrights and trademarks as well. First of all, what is a patent? A patent is the monopoly right in the use of an invention. If you invent something, so you have the monopoly right on that invention. Others cannot use it, provided your invention is protected through a patent. So now it is clear basically that patents are granted for inventions. So your inventions are recognized as intellectual properties by granting patent rights. It should meet three important tenets. What it here it is referred to your invention. So it is not that if you club some two balls or two boxes with a wire and say it's oscillating, it's my invention, give patent. No one will give you patent. Rather, there must be some criteria to decide what is an invention and what is a mere duplication. So, the concept of invention should meet three important aspects, namely novelty. Absolutely a new one you have created. Novelty means new one. Non obviousness, that means it is unknown to others so far. Obvious means it's well known, it's known to everyone, it's by default, it's known to everyone. Non obvious means unknown to others. So, it came out only because of your invention. Capable of industrial application. Your invention must have capability of industrial application. So what is this industrial application? Let us take a small example to make it simple. You all seen this Three Idiots movie, isn't it? So in the very beginning, one of the hostel mates of our hero Amir Khan, he says, I have prepared a helicopter or a chopper that can fly for my project work. Then our virus says, okay, then your project is rejected. You submit next year because it is meaningless. So that is not patentable. But what our hero does next comes and says, he puts some small camera to the chopper so it flies and takes the photographs or videographs images of high altitude areas so that we can use it for rescue operations whenever occasion. That is called industrial application. So mere invention, mere creation is not patentable, rather it must have industrial application. So it must be novel, that is absolutely new, non-obvious, that means unknown to others so far, and it must have industrial application. If these three are met, then it is called an invention which is eligible for patent protection. Of course, it's a legal property which can be sold, gifted, destroyed like any other asset. So once you obtain patent, patent is your asset. You can sell it to someone, you can gift it to someone, or you can even destroy it if you don't like its outcome, right? A person owning patent is known as the patentee, right? Generally, the innovator himself is the patentee. But if it does it in the name of a company or on behalf of some company, the work is called commissioned work, for which the inventor will not be the patentee. Rather, patentee will be the company which sponsored his invention. Generally, that happens in the case of pharma companies, where scientists will work in the capacity of employees and they will create inventions in the name of company, and hence patentee shall be the company. So such works or such inventions are called commission works in the case of patent literature. Now you got it? Patent is a monopoly right given for inventions. It's an important intellectual property right. Invention should meet three important attributes, namely novelty, non-obviousness, and it is capable of industrial application. So your patent is a legal property. It's a very much asset which can be gifted or done anything that you do with your normal asset. And of course, once you own patent, you are called a patentee, right? So once your patent is an asset, recognized an asset, it must have protection. So patent protection in India is I mean, it dates back to 1970s. So patents are protected through the Patents Act 1970 in this country. So way back, some 40 years ago itself, we had a law for patents protection. And Patents Act 1970 has been amended after the incarnation of WTO in the year 1995. Friends, not only patents law, all the laws governing intellectual properties are subjected to a landsliding change after 1995 because in 1995 GATT, that is General Agreement on Trade and Tariffs, is converted into an organization, that is World Trade Organization, to which India is a founder member, one of the founder members. So we were left with no option but to adhere to the guidelines of TRIPS in WTO. There's an accord called TRIPS, Trade Related Intellectual Property Rights. So that accord or that agreement occasioned all the member countries of WTO to give equal and fair treatment to the patents of both abroad and domestic inventions. Second, it wanted to grant trade rights or tradable rights on inventions such that trade can be promoted on free and fair basis. So accordingly, India had amended its intellectual property laws, and so is the case with our Patents Act 1970. So now let us see how the Patents Act 1970 looked like before WTO, what were the basic provisions, and we will also see what are the major amendments that Patents Act 1970 had undergone after the incarnation of WTO. So your Patents Act 1970 first says how to obtain your patent. That's very important to learn. So once you feel that your invention is novel, non-obvious, and it is capable of industrial application, you must file a formal application along with the description of the invention, and it should be sent to controller of patents. Right? The controller of patents is headquartered at Kolkata. So the controller refers to it to an examiner. Who is an examiner? A subject expert. So you may have invention in pharma, you may have invention in electronics or electrical. So as per the subject or based on the subject, the controller will identify the examiners, the panel of examiners will be there. So one examiner or two examiners at the discretion of the controller, it will be examined. Generally, the norms are such that three different examiners have to cross check the non-obviousness, industrial application, and novelty of the description, which is sent along with the application. So a public notice shall be given to hear objections upon the endorsement of the examiner. So once examiner says yes, it is patentable, then the controller gives a public notice. So if anyone having objections on this invention, if anyone claims that it is your invention, or anyone says it is not patentable, so you must raise your objections within 15 days. So if no objection is brought to the cognizance of the controller within 15 days, the patent right is granted to the applicant and published in the official gazette. So once it is officially declared in the gazette, then the applicant shall be the patentee and enjoy monopoly right in the use of his invention. Clear? So simple process to look, but it is very tedious to go through. Once you have invention, you must clearly describe it, then send it to controller will send it to examination, that is subject experts must endorse it that it is patentable, then public notice will be given offering any objections from the public, then no objection comes from public within 15 days, finally the official gazette will be released that patent is granted in your name. That is the process, right? Of course, the process I told you, it's very rigmarole, though looks very simple. So once you understood the process of obtaining patents, now let us see how many types of patents are there. Actually, Patents Act 1970 bifurcates patents into product patent and a process patent. So product patents, which were protected for 15 years from the date of registration, provided a license is obtained to produce the patented product on commercial grounds. So before we see this nitty-gritty of commercial license and all, let us first understand the difference between product patent and process patent. Product patent is more superior to process patent. Why? Because the product patent protects both procedure involved in invention as well as the ultimate outcome. So procedure means the combination of inputs used by the patentee as well as the steps he has fostered to incarnate the product or service. So both are protected. Your combination, that is the procedure of invention, as well as the ultimate outcome are protected from infringement. That is called product patent. On the other hand, process patent means only the procedure which patentee has followed, only the combination of inputs which patentee has used will be protected from infringement. So the ultimate output will not be protected, right? So why this provision was inserted in those days? Reason is obvious. We were having scarcity of medicines. So what our scientists, I mean, I should not make it public. So what few scientists rather did in few countries, I must be very cautious because this video goes into public. So few scientists in few countries, what they did is they used to import medicines from other countries, and they used to examine in the labs what was the combination of chemicals used to make the medicines. So they used to make slight changes with substitutes. This is called reverse engineering. So taking output and going back to the inputs. So they used to say, sir, we have come forward with slight different combinations of inputs. So this is our process. Also give us permission to produce it. That was process patent. So don't you think that the genuine inventor who invented the medicine first is deceived here? Certainly, yes. But the law was designed in those days such that only process patent, I mean, was granted to medicines. I'm taking medicines as an example, but there were few other categories also to which process patent was alone granted, but not product patent. So that any scientist buying the product, the ultimate product which is already patented, taking it to his lab, making a small tweak or making small change in the input combination with substitutes, he was also entitled to get process patent. So simply remember that process patent will not grant protection for ultimate output. Rather, only the procedure involved in invention alone was protected through patent. That is process patent. Now you tell which is more superior, product patent or process patent. Certainly it is product patent because it protects both product as well as the procedure, right? So in those days, that is before WTO, product patent was protected only for 15 years and process patent for 5 years. And very important thing here we have to observe, in those days, that is before WTO, though you obtain patent, you are not supposed to produce it immediately. There was a provision for compulsory licensing. You are occasioned to obtain compulsory license from the concerned departments of your invention, then commercialize it. So once you obtain commercial license, then it will be protected for 15 years. You may ask a question, if I don't obtain my license, 15 years will not be counted. No, the provision was like this. So from the date of granting protection patent, within 3 years, you should have obtained license and commercialized the product. Otherwise, there was a peril of losing patent protection. That was very undue, isn't it? So these were the flaws we had in earlier laws. So product patent is more superior to process patent because product patent protects both output as well as your process. Whereas process patent protected only for 5 years in those days, not now, was protecting only the process but not the ultimate output. In the case of process patent, there's nothing called compulsory licensing. But in the case of product patent, compulsory licensing within 3 years from the date of obtaining patent was there in existence. Clear? So I told you that process patents were granted to chemicals, fiber optic cables, certain category of medicines, right? So these were eligible for process patents. Of course, there was a controversy before WTO that medicines were not eligible for patent protection, though some relaxations were granted in later 80s. That we'll understand later, right? So, friends, what type of inventions are patentable? Is there any possibility to enlist the inventions which are only eligible for patents? No doubt, novelty, non obviousness, and industrial application are very much the essentials. But is it possible to list out the inventions which are patentable? No, because we don't know what a scientist is going to invent tomorrow. So, what we do is we come in a reverse order. Our law says inventions which are not patented, which are not patentable. Let us see what are those. Anything frivolous and contrary to well established natural laws is not patentable. Naturally, something which is contrary to well established natural laws, what is that you are inventing? You can't. Similarly, frivolous. Frivolous means meaningless. Meaningless inventions are not patentable. Rather, it must have industrial applications. Mere discovery of existing thing, living organism, or new property of existing thing are not patentable. Mere discovery of existing thing is not patentable, obviously. So do you say that Columbus discovered America or Columbus invented America? We say discover because it's already there in nature which you found. That is called discovery. It's not your creation. Invention is creation, discovery is mere finding. So discovery of existing thing in the nature is not patentable. So there's a difference between discovery and invention. Living organism, suppose you are making a march into Amazon forest, right? You are just shooting the breeze, killing the time, and you found some rare species, very, very rare species. You shot that with your camera or your video cam, and you say, hey, Eureka, I found it. So it's my invention. Will you get patent for that? No, because living organism is not your creation, it's God's creation. So it is not patentable. Of course, living organism created through biotech inventions is now patentable, that we'll see next. Similarly, new property of existing thing is not patentable. Suppose you found in your lab that water, if it falls from high altitude, has got capacity to generate power. So can you say I found that water has got power generation capacity? So give me patent only. I mean, give patent only to me for generating hydroelectric power. Will you get? No, because water is a natural phenomena, and you simply discovered it that whenever it falls from high altitude and goes to some machine, it generates power. So entire power on hydroelectric capacity must be my property. You cannot say like that. So rather, if you invent a turbine, a machine, a turbine that is used for generating power, for that you can obtain patent because it's your invention. But generation and power generation capacity of water is not your invention, it's your discovery. That's the existing property of water. So that is not patentable. Mere formulation of theory or abstract is not patentable unless it results in a new invention, right? For example, one scientist says F is equal to ma, force is equal to mass into acceleration due to gravity. Will he get patent for that? No, it's mere formula. Is force his invention? Or mass his invention? Or acceleration due to gravity is his invention? Certainly not. They are existing phenomena in the nature. So, mere formulation of theory is not patentable. But if such formulation results in some new output exactly, then it is patentable. Suppose one scientist in a lab makes a formula for manufacturing a chemical, manufacturing a a medicine, that is patentable now. So if your formulae, if your theory is drawn only and only for invention of a product, it is patentable. It's a know-how, technical know-how that has to be protected, no option. So, but mere formulation of theory is not patentable. F is equal to ma is not patentable. Based on F is equal to ma, if you develop some new theory or some new formula and invent a Formula One car, You may say, yes, it's my invention, give me patent, you will get it, but not for a physical TMA, please. So, mere admixture or duplication of existing products is not patentable. Mere admixture, that means already existing products are coupled together or simply duplicated, you will not get patent protection, right? Some time ago, we read in the newspapers that one boy, a small boy, who saw that his father was going into farm to put water in the night times, because governments in some areas give power to farmlands only in the night time. So he was venturing into farms in the night time to release water, to switch on the motor, that is power. So, and he saw that few of the farmers going along with his father had snake bite and died because it was night time. So that boy, what he did is, he has used cell phone, some modifications he made, and proved that we can switch on the motor in our farmland just sitting at our home using your cell phone. You can switch on the electric motor that gives water to your farm. So he said, it's my invention, give patent. But government did not give patent for that. Why? Because cell phone is not his invention, electric motor is not his invention, it's only admixture. So he only discovered property of existing patented products. For that, patent will not be granted. Similarly, this one, last provision, is very important because it is done away now. Any medicinal, surgical, prophylactic, and therapeutic inventions were not patentable in those days. That is before WTO. So, government thought that medicinal, surgical, therapeutic, and prophylactic inventions must be made available at larger public disposal, so they should not be confined to the rights of patentee alone. So therefore, these medicinal, surgical, and prophylactic inventions were not patentable in those days. How unfair it is. Suppose a scientist invents pacemaker for improving the heart functioning. He was not allowed to have patent in those days, though it was a genuine invention. Naturally, it's unfair. So, government, in consultation with WTO, had to make these unfair provisions do away and came forward with very fair and protective mechanism. So let us see what inventions are now patented, or what type of amendments rather we have brought forward after incarnation of WTO. So here are the major amendments that Government of India made to Patents Act 1970 in the post WTO scenario. One, bioorganisms like new seeds are also eligible for patent protection. Remember in the previous slide that living organism was not patentable, but now we say that if such organism is created in the lab, especially in biotechnology sector, so they are genuine inventions of the scientists. You cannot deny their right of having patent. Therefore, now government says that bioorganisms like new seeds are eligible for patent protection. For that purpose, Biodiversity Act 2000 has come into existence to grant protection to these bioorganisms, which are inventions in the labs. Both product and process patents are now protected for 20 years. Remember in the previous slides that product patent was protected only for 15 years and process patent only for 5 years. Now that discrimination is done away, now we say that both product and process patents are protected for 20 years. The concept of compulsory licensing to commercialize the patented product has been done away, except in the case of notified products. Obviously, suppose one scientist had invented a product, but he did not have proper money or sufficient money to commercialize the product. So within 3 years, if he don't obtain the license and commercialize, he was a loser. He was forced to lose the patent right. How unfair it is. Therefore, now government says that compulsory licensing is done away. Once you obtain patent, 20 years you are the owner of patent. You can do anything in this 20 years. Of course, compulsory licensing is now also remains compulsory for few products, especially those hazardous products like chemicals, medicines and all. Other than that, no compulsory licensing is required to commercialize the patent. Agricultural equipments are also brought into the ambit of patents. Yes, please. In previous era, that is before WTO, agriculture inventions were not protected. Suppose a sprinkler, a drip irrigation equipment was invented. It was free from patent. Anyone could infringe it. Anyone could copy it. That is also unfair. So government said, now yes, we will recognize agriculture equipments also to the ambit of patent protection, right? Medicinal inventions are allowed to be patented now, by virtue of which only now pharma companies grew so big and occupied a big landscape in the global markets, isn't it? So, in earlier cases, the medicinal, therapeutical, surgical, prophylactic were not patented. But now we say that medicinal inventions are also allowed under patent protection. So, these are the major amendments, of course, very fair and required amendments that were made to Patents Act 1970. Hope it is clear to you what is patent, classification of patents, how it must be obtained, how the law looked like before 1995, and how the law is now looking like. Clear? So, see you all in the next class with another topic on intellectual properties. If you have any doubts, please feel free to revert back at 98495 60102 or nsureshnaidu at gmail.com. Be safe. Have a nice day. Bye.